Hello friends, my name is Asim Pandya. I am a designated senior advocate from High Court of Gujarat, Ahmedabad. I am an author and former president of Gujarat High Court Advocates Association. Through this video, I am proposing to launch a nationwide campaign for the abolition of practice of designating senior advocates, and I am also seeking the parliamentary intervention to repeal section 16 of the Advocates Act, which has created this kind of division of a single class of lawyer into two classes. One is an elite class or grand lawyers, and another is general lawyers. My friends, this kind of discrimination under our constitutional scheme cannot be permitted at all. Recently, a noted jurist and an eminent lawyer, Mr. Fali Nariman, has said that Section 16 of the Advocates Act has introduced a caste system in the legal profession. It is anachronism and it needs to be abolished immediately. That is what he has stated. He has stated that our system or our practice of designating senior advocate is mirrored on the Queen's Counsel system which is prevalent in England. Since we have completely disintegrated ourselves from the British Empire long back, it is high time that the practice which is based or which is mirrored on the Queen's Counsel system of British government needs to be abolished in India also. So these are the views of Mr. Nariman. I would like to point out that I am having the same view. I am making protest against this practice of designating senior advocates for last more than 5 years. My protest started with an article on this topic. The title of the article was that practice of designating senior advocates, the red beacon of the legal profession, needs to be abolished. Thereafter, when I was inducted in the subcommittee of the Bar Council of India, which was to look into the 266th report of the Law Commission, which has suggested several reforms in the Advocates Act 1961. In response thereto also, our subcommittee has clearly stated that Section 16 needed abolition immediately. When Indira Jaisingh's case was filed, which wanted transparency in the practice of designating senior advocates, when the case was being heard, I, as a former president of the Gujarat High Court Advocate Association, filed an intervention application in Indira Jaisingh's case, and we said that Section 16 of the Advocates Act be declared ultra vires Article 14 and Article 18 of the Constitution of India. Last year also I made representations to Honorable Prime Minister, Honorable Law Minister, Learned Attorney General, to the Leader of the Opposition, to the Chairman of the Law Commission, to the Chairman of Bar Council of India and other authorities. I have not received a single response from any of these authorities except from the Office of the Learned Attorney General, wherein also a mechanical reply has been given that whatever points are raised in your representation have been answered in the judgment of the Honorable Supreme Court in Indira Jaisingh's case. Except that, I have not received any response from other authorities. In fact, I had sought an appointment with the Honorable Prime Minister to explain him that this practice of designating senior advocate and dividing a single class of lawyer into two classes is per se invidious, and it creates a large-scale heartburning among the lawyers, and therefore it deserves to be repealed, and the Parliament must intervene to bring justice to the lawyers. But I have not been given appointment by the Office of the Honorable Prime Minister till date. I am trying to just bring to your notice what are the important aspects of the practice of designating senior advocate by the court. The first question which must arise in your mind is that whether this kind of practice has any historical sanction at all or not. We are laboring under the impression that this kind of practice is being done or it is prevalent from time immemorial. That is our conception, or we may say misconception. We think that this kind of practice is prevalent in the past also. But when I examine all the laws, starting from the Regulating Act 1773, Legal Practitioners Act 1879, Bombay Pleaders Act 1929, Indian Bar Council Act 1926, Government of India Act 1935, and all the charters issued under the laws, that is Indian High Courts Act and other laws, there is no such practice evolved by our courts during the British rule. Let me point out that all those judges, British judges or Indian judges, were quite aware of the system of Queen's Counsel, which was prevalent in England since 1597, when Mr. Francis Bacon was conferred the title of Queen's Counsel for the first time. So in England, this kind of system is in vogue since 1597, and despite that, the British judges or the judiciary during the British rule has not evolved such a system. So the answer to the first question, whether it has any historical sanction at all or not, the answer is emphatic no. There is no historical sanction so far as India is concerned to such a practice being followed by any court. So court conferred recognition or designation of senior advocate was not at all prevalent in India prior to the Constitution of India. So immediately the next question will arise in your mind is that how this system got to be introduced in India. There is an interesting account of that. I would like to point out that this system was introduced by Bombay Bar Association on its original site purely on voluntary basis and for different reasons. The reasons were that in those days, the leading lawyers of the Bombay High Court original site were having almost majority of cases with them. So the law cases were concentrated in a few hands only. And the new entrants in the profession or the junior lawyers did not have sufficient work. So it was proposed by the senior advocates on voluntary basis that to see that the junior members can sustain himself in the profession and he also gains sufficient experience, the senior members thought that we should restrict our practice, and in reciprocation thereof, they were being recognized as senior advocates, and they would voluntarily accept the restriction that they would not appear without the aid of the junior lawyer. They would not take up small cause cases or petty cases or notice of motions. They would not draft pleadings, etc. So these kind of voluntary restrictions were accepted by the senior members, and the reason was that the junior members get sufficient experience and also they can earn from the profession. The criterion was that person should have a practice of 10 years or more. Only those persons were entitled to get themselves enrolled voluntarily, and the option was available to every lawyer who had a practice of 10 years or more. So this is how interestingly this practice was introduced in India. But please mark that this was not a court-conferred distinction or a title. It was purely recognized by the Bar Association itself. Now, when Supreme Court was established in 1950, the Supreme Court Practice Rules, Order 4, Rule 7 provided for a similar pattern of recognizing a senior advocate. Order 4 Rule 7 of the Supreme Court Practice Rules provided that any lawyer having practice of 10 years or more would be entitled to be called as a senior advocate, provided he gives an undertaking that he would restrict his practice and he will not take up the small cases or petty cases, and they would not indulge into drafting, and they would appear with the junior lawyers only. Now this practice prevailed in Supreme Court up to 1954. So it was broadly based on the system evolved by the Bombay Bar Association. But in the year 1951, All India Bar Committee was constituted to make suggestions with regard to the legal profession and legal system. The All India Bar Committee was chaired by Justice S.R. Das, which examined the legal profession and various grades of lawyers that were prevalent in those days. In those days, and during the British rule, there were several grades of legal practitioners came into existence or emerged. The grades were like this. Mukhtars were there at the subordinate court levels. Mukhtars were there, Vakils were there, pleaders were there, attorneys were there, solicitors were there, advocates at High Court level, and barristers at High Court level. So these kind of various grades were prevalent in those days, and on account of these different grades, in the same bar association there were different associations were formed, and certain members were not eligible for availing certain privileges which were available to advocates or barristers. So there was a kind of discrimination prevailing on the basis of the grades of the legal practitioners. So this All India Bar Committee made a suggestion that these various grades needed to be abolished and the legal practitioner should be called by a single name advocate only. So that was a very crucial suggestion. Now this committee had an opportunity to examine the Supreme Court rule which provided for automatic grant of recognition to an advocate having practice of more than 10 years or more. The All India Bar Committee noticed that the title of senior advocate was greatly abused by the recognized senior advocates automatically. So these automatically recognized senior advocates would only follow the restriction when they practice in Supreme Court of India. But when they practiced outside the Supreme Court of India, they did not follow the restrictions. Importantly, they were using the designation or recognition senior advocate on their letterheads, then visiting cards, and on the nameplates of the office, outside the office. So it was being abused and misused by the senior advocates, and therefore the All India Bar Committee suggested that this kind of system must discontinue, and again an argument was made by some that okay, if there is no automatic recognition of an advocate as senior advocate, let us introduce a system where a lawyer is invited by the court to become a senior advocate based on his merits or his standing or his ability. This was also objected to by the All India Bar Committee, saying that this would result into canvassing for the recognition and it would seriously prejudicially affect the fearlessness of an advocate, and it would create a bar which would not remain independent because everybody would be seeking recognition of a court-bestowed senior advocate's recognition. So the committee was of the view that no such distinction should even prevail on merit, and therefore they said that no such division should be allowed. Only at Supreme Court level, for the special reasons, it was suggested that there should be there is a necessity to introduce a system of advocate and record and arguing advocate at Supreme Court level, because in Supreme Court, lawyers from all India come and appear, and there has to be someone locally to look after, to act on behalf of the client and to be accountable when case is listed for hearing. So for these various reasons, the practice of advocate on record based on objective evaluation, namely appearing in the examination and passing the examination was suggested. Except that the All India Bar Committee was clearly of the view that this kind of division is impermissible and it should not be continued. The second important document which I am going to talk about is 14th report of the first Law Commission. It is an interesting document. Please refer to volume 1, page 566 to 572 of this Law Commission's recommendation in its 14th report. This 14th report has examined the entire legal profession and has made various suggestions. Please remember this, that this first Law Commission in its 14th report has made several recommendations, but these recommendations are not based on the study of the provisions of law, or while making recommendations, the Law Commission had not kept in mind the constitutional provisions, namely Article 14 and 18 of the Constitution of India. The recommendations were principally based on the views elicited from the different associations of the advocates. So different bars where their views were taken into account. Then the views of the individual lawyers were also taken into account. The views of the junior members of the bars were also taken into consideration. And on the basis of such views, the first Law Commission made a recommendation that we ought to have, or we should have, a division of advocates into two. One is a general advocate, another is a senior advocate. This division was, as I pointed out, it was based on the views of the representatives of the legal profession. But even their views were not unanimous. There were divergent views among the lawyers and the bar associations. Somebody said that it was not possible to be implemented at district level, because at district level there are no senior advocates, designated senior advocates appointed or bestowed this kind of title or recognition at district level. So it would not work satisfactorily at district level. Then some of them said that it is not in the interest of profession also. But be that as it may, the first Law Commission in its 14th report recommended that there should be a division of a lawyer into two classes, one general lawyers and another is senior advocates. While making recommendation, the first Law Commission has in its mind the Queen's Counsel system which was prevailing in England. So they wanted a similar sort of practice in India also. Now you are all aware that in England, the titles and hierarchy in society is an acceptable norm. In India, it is constitutionally prohibited. So there is a fundamental difference between the systems which is there in England and in India. Our constitution specifically prohibits such kind of hierarchy of society or conferment of title under the constitutional provisions. So whatever may be the reason, but it is evident from the report that the first Law Commission wanted a similar system in India that is prevailing in England, that is Queen's Counsel system. Now importantly, at that stage, some people argued that what should be the name of the person who is to be designated or recognized as a senior advocate, and views were expressed that it should be a President's Counsel, or somebody said that he should be described as a Republican's Counsel. But the first Law Commission said that at least in Bombay Bar Association and under the old Supreme Court rule, they were being described as senior advocate, and therefore we should continue with the same rather than President's Counsel or Republic's Counsel. So the idea of emphasizing on this aspect is that the Law Commission wanted a similar system, that of Queen's Counsel system in India, and which is, as I said, that it is not permissible under our constitutional scheme. But I will advert to that aspect a little later. So on these recommendations, Section 16 of the Advocates Act was introduced. Now coming to the point that how this system is recognized in our constitution. Whether it is a constitutional jurisdiction, it is an inherent jurisdiction vested in superior courts of record or not. This is also an important important question which needs to be answered. There is a great misconception that Supreme Court and High Courts are involved in the process of designating. People have some misconception that it is either an inherent jurisdiction or it is a constitutional jurisdiction. Let me dispel this misconception that it is neither a constitutional jurisdiction nor an inherent power invested in courts of record. Neither Article 129 of the Constitution of India nor Article 215 of the Constitution of India has conferred such a jurisdiction or power in the High Court or the Supreme Court of India. There may be an argument that since these courts are created as court of record, this kind of inherent jurisdiction has to be presumed. But there also again I may clarify that since there was no such practice ever since the institution of court, superior court was created during the British rule, this kind of power cannot be considered to be an inherent power vested in the High Court or the Supreme Court of India. So there is no constitutional sanction or it cannot be recognized as an inherent jurisdiction. Then what is the nature of this jurisdiction? I would like to point out that it is purely a statutory function undertaken by a High Court or the Supreme Court of India under Section 16. So it is pure and simple statutory power. And once it is held to be a statutory power, automatically it would be amenable to the power of judicial review. And the power of judicial review cannot be restricted on the ground that the persons who are involved in the process of designating are High Court or the Supreme Court, and therefore there should be a limited judicial review. That is not applicable because this is a statutory function, and whatever is being done by the High Court or the Supreme Court of India is exercise of a statutory jurisdiction. So, but this would be relevant provided the provision is held to be constitutional. In my view, per se, these provisions are unconstitutional. Now I will try to demonstrate how these provisions are unconstitutional. Let us first test these provisions from the angle of Article 14 of the Constitution of India. The Article 14 provides that there should be an equality of law and equal protection of law. Equality before law and equal protection of law. Here, there is a class within the class of a same person or persons having same degree. A person is entitled to carry on the business or profession, I may say profession of law, provided he possesses a basic degree of LLB or Bachelor of Law. So that is a fundamental requirement. So all legal practitioners are having the same degree. Now once they are having the same degree, what is the justification for creating a subclass or a higher class of lawyers among the same class of person having same degree? Some lawyers might be possessing higher degree, that is LLM, LLD, but that is not significant in the matter of conferment of the designation of senior advocate. So fundamental defect or fundamental point which I would like to urge is that there is no need of creating a class within the class having similar qualification. So on that count it is violative of Article 14. Now the second aspect which I would like to highlight and which is based on the recent doctrine of the manifest arbitrariness. Earlier view was that if there is a classification, reasonable classification, and the classification is based on intelligible differentia, and the classification has an object sought to be achieved, then it would be saved by the provisions of Article 14 and reasonable classification. So a legislation can be tested only on those principles, but now the doctrine of manifest arbitrariness has been evolved by the Honorable Supreme Court of India in Shaira Banu's case, and later on followed in few more decisions. Now I will demonstrate how this can be termed as manifest arbitrary. Let us recall what was the recommendation and how these recommendations came to be made by the First Law Commission. As I pointed out, that First Law Commission simply elicited views of the members of the legal profession and certain associations. So it is based on the views of the stakeholders and it is not based on the research. If we read page 566 to 572, there is no reference of Article 14 or 18. So while making recommendation, the Law Commission has not kept in mind the provisions of Article 14 and 18, which says that there has to be equality before law and equal protection of law, and Article 18 prohibits conferment of title or distinctions. So this was a fundamental defect, that it has not adverted to, the Law Commission has not adverted to the constitutional mandate and the constitutional prohibition while making the recommendation, and on that basis Section 16 has been enacted mechanically by the Parliament. So Parliament has chosen not to apply its mind to the constitutional mandate or the constitutional prohibition. So that is how it would be construed as manifest arbitrary. There is complete non-application of mind to this important aspect. Now, another aspect which is also important to note is that I have myself tried to find out what is the rationale. What are the objectives sought to be achieved by creating or evolving this kind of system of designating senior advocates? Friends, I have failed to find out any good reason or good rationale for evolving such a practice in India. The society or the legal system does not derive corresponding benefit upon conferment of the distinction of a senior advocate to an individual lawyer. It has no rationale at all. First answer has to be that there has to be some benefit to either society or to the legal system when somebody is conferred the designation. So it has no corresponding benefit to the legal system or the society at all. So on that ground, there is no good rationale at all. Now, importantly, let us assume that the classification is reasonable. Of course, it is not reasonable because it is based on standing, it is based on the ascertainment of his ability and his knowledge of law or experience in law. So these are the criteria on the basis of which a person is to be given this kind of designation by the court. Now, as I said that since society is not deriving any benefit, I would say that it is a pure and simple license conferred by a court to an individual advocate to earn more income and to enjoy a higher status. Except that I don't find any other rationale. So it is merely a license issued by a court to earn more income and enjoy higher status. With greatest respect to the institution of court, the court should not become party to such a unconstitutional practice. Why High Court or Supreme Court should become party in getting somebody earn more and enjoy higher status? It is for the court to look into it, and they should not spend a single hour on the practice in finding and inviting applications, employing few persons to arrange the applications and then holding meetings to decide who is to be conferred and who is not to be conferred this recognition. So court should not become party to such an illegal practice. So that is another flaw in the current practice of designating senior advocates by the court. Now, coming to the next point, that is how this practice would violate Article 18 of the Constitution of India. Apparently, you might find that Article 18 simply states that the state shall not confer any title to any person. So it gives an impression that it has to be a title. Now, what does the title mean? So arguments may be raised that this is not a title, but this is a distinction. But if we closely read Article 18, it would reveal that title has been used, the word title has been used in a broader sense. It has been used loosely to include within its sweep any distinction barring military and academic distinction, because if you read it, it clearly states that state shall not confer any title to any person except military and academic distinction. So they have carved out this kind of distinctions which are based on objective taste or military distinctions. So barring this, if any other distinction is there, then it will have to pass the test of Article 18. Now if we see Section 16, what are the criteria? Standing at the bar, his ability, his knowledge of law, or in experience of law. So virtually it is not, or physically, or we may say that it is very clear that it is not an academic distinction. It is a distinction of a different kind and which has to pass the test of Article 18. And in this regard, I would like to again draw your attention to the All India Bar Committee's report, which has stated that the title of senior advocate is being greatly abused. So the All India Bar Committee described it to be a title. The Law Commission has said that it is a distinction or an honor. But once the Law Commission made it clear in its report that it wants a similar system like Queen's Counsel system to be brought in India, it automatically becomes distinction or a title. Because in England, it is an honor of excellence or it is a distinction. But as I said that England, this kind of hierarchy or titles are permitted in England. You are aware, all Marquis, Duke, Baron, all these kind of titles are prevalent and there it is not prohibited. But if we compare the system with Indian system, then it is definitely, our constitution does not permit such a thing. So it would be obviously a title or distinction which has to pass the test of Article 18 and it is prohibited in fact. Now one more important aspect is there is one Supreme Court judgment which has tried to explain what does the title mean under Article 18. The case is Balaji Raghavan versus Union of India, which is reported in AIR 1996, Supreme Court page 770. In that case, the constitutionality and validity of the conferment of civil awards like Padma Shri, Padma Bhushan, Padma Vibhushan, so and so forth was challenged. And it was said that these are the titles and therefore they are hit by Article 18 of the Constitution of India. Supreme Court repelled the contention saying that these are the civil awards, but while upholding the constitutionality, the Supreme Court said that, put a rider, that these civil awards are not to be used as prefix or suffix with the name. And if a person who is awarded such a civil award uses it as a prefix or suffix with his name, the award is liable to be forfeited. So once and while making such observation, Supreme Court says that hereditary or non-hereditary title, if a title or distinctions, if they are being used as a prefix or suffix, then it becomes a title within the meaning of Article 18 and therefore it is not permitted to be awarded by the state or instrumentality of the state. And here the Supreme Court and the High Court is exercising power under Section 16, so it is a statutory authority and it is not discharging its judicial function, and therefore there cannot be any debate that it is not a state or instrumentality of state while exercising jurisdiction under Section 16 of the Advocates Act. So, in this Balaji Raghavan's case, there are three tests laid down. One is that the distinction or title should not be used as a prefix or suffix. Now, by virtue of this kind of distinction, if there is a separate and identifiable class is created, then also it will have to be kept in mind while judging whether it is a title or not. So, it should not result into creation of a separate and identifiable class which is separate from the rest of the other people. And third thing, there should be certain privileges attached to the title or distinction. Now let me clarify that I did not elaborate that what are the privileges of a senior advocate. Now senior person, when person is conferred a distinction of senior advocate by the High Court or Supreme Court of India, he enjoys several privileges. The first privilege is provided in Section 23 of the Advocates Act itself, that when cases are being argued in the court of law, the senior advocate has a right of pre-audience. So among the similarly situated lawyers, he would be entitled to a first audience in this matter. So it is a special privilege. Then they are separated by different dress code. For them there is a different kind of gown provided for, different kind of collar and different kind of coat is there. So they are identifiable as a different class of persons. Additionally, in all state panels, there is a higher fee for the designated senior advocate. So it's a special privilege which otherwise if the court had not granted recognition, he would be entitled to a particular fee, X fee, and when he is recognized as a senior advocate by the court, he would be entitled to charge more fees. So that is another privilege. Now in all court proceedings, he is addressed as a senior advocate. So not only in the court, in judgments also he is addressed as a senior advocate. Outside the court also he is given the status, higher status or elite class of persons, senior advocate, and he is entitled to use the word senior advocate on his visiting cards, on his letterheads, on the nameplate outside his office. Then in all official functions of the High Court or the Supreme Court of India, the designated senior advocates are given special invitation, separate individual invitation, whereas other lawyers are given general invitation through the bar association. For senior lawyers, there is a separate arrangement for sitting. So not only in the functions of the High Court, whenever law function is arranged by the state government also, there is a separate invitation. So these are the special privileges which are given to the senior advocates, which they actually all lawyers, since they are similarly situated, I am objecting to this kind of privileges being extended to a one class of lawyer having the same educational qualification. So on this count, on all these three counts, the word senior advocate would acquire the meaning of title within the provisions of Article 18, and it is violating that provision, and therefore also it is liable to be struck down. So this is from constitutional angle of Article 18. Now let me point out few other important aspects. Whether the USA has such a system or not. We cannot simply look back at England or other countries which were originally ruled by the British Empire. Wherever the British Empire had ruled, similar system is in vogue despite the nation getting independence. So we will have to look at the USA. In USA for last 200 years, there is a single system of an advocate and there is no such division. So merely because it is prevailing in England, there is no justification for continuing it in India also. In England also, there were protests against continuing this system. In year 2003, Lord Falconer suspended this practice of conferring title of Queen's Counsel for a period of 5 years. But later on, because of political pressure and peer pressure, the system has been restored with certain modifications, but that again would not be a justification for continuing this system in India. Now, one important document in England also that is very relevant, that is Office of Fair Trading. Office of Fair Trading has also examined it from the angle of competition and fairness, and it has found that it is anti-competitive and it is not at all fair, and the consumers of legal services do not require such a brand being given or such a recognition being given to anyone. So this is the report of the Office of Fair Trading in England also, but as I said that all this is not significant in India because our constitution is totally different, which prohibits such kind of creation of elite class of people in India. So this is one aspect. Secondly, if I may give instance of Gujarat High Court. Gujarat High Court was created in 1960, and in Gujarat High Court itself there was no such practice evolved for more than 31 years. The practice of designating senior advocates started only in the year 1991. For the first time, this kind of practice was implemented in Gujarat High Court. Now, if we see the contribution of the senior lawyers who were not designated senior advocates and the designated senior advocates who have been conferred this designation after 1991, if you examine the law developed by both the sorts of lawyers, there is no difference. Earlier lawyers have also contributed the same thing, and the current designated lawyers also have the same. So I am trying to highlight that the contribution of a designated senior advocate equated with the other senior advocates is nil. There is no difference. I have not found any remarkable difference in the quality of the judgment or in the reforms being made in the legal system or any other type of contribution in the research or academics by the senior advocates. So the contribution on account of designation can be considered to be nil. Therefore, it is absolutely irrelevant and insignificant, and this kind of practice needs to be abolished. Another important aspect is that it is a burden on the state coffer. As I pointed out that a person on his own competence, he should be allowed to thrive in his own competence, and he should be entitled to court based on his own competence. What happens once person is designated immediately, his fees are increased multifold. In 1672, in England also, Francis Winnington was when appointed Queen's Counsel, his fees multiplied tenfold. So here also, merely on account of conferment of designation, the instrumentality of state, and state has to pay more fees to the lawyers, and this is a burden, unnecessary burden on the state coffers. As I already mentioned that in subordinate courts, this practice has no relevance. In the district court, in the magistrate courts, there is no distinction or there is no division of such court designated senior advocates and general advocate. So that is also one important factor one must keep it in mind. So bearing the overall aspects of the practice, I am of the firm view that this is absolutely discriminatory. An elite class of lawyers are created and same facility is not available at district level, and here there is a large scale resentment among the general lawyers that why only particular lawyers are chosen as designated senior advocate. So with this I conclude this video. I earnestly request that if you agree with my views, please sign the petition which is attached with this link of the video, and try to support the movement. We should seek parliamentary intervention in repealing Section 16 of the Advocates Act 1961, and alternatively, if within a reasonable time the parliament doesn't intervene, then I propose to file a review petition in Indira Jaisingh's case, where several aspects have not been dealt with or improperly dealt with by the Supreme Court of India, and the principle of manifest arbitrariness was not evolved when the said judgment was given. So I thank you all for watching this video. I will meet you again. Thanks.